A. In or about year 2015 files a suit against his father and two brothers, pleading that the grandfather had in the year 1960 purchased the house in which all the parties to the suit was residing, and that the grandfather had died in the year 2000, bequeathing the said house to his father and claiming partition to the suit house. Being ancestral property, one of the two brothers, A, impleaded as defendant, supports the case of A, and the other brother is proceeded against ex parte. The father files an application under Order 7 Rule 11 of CPC for rejection of the plaint, stating that A or his father's sons have no share in the house. Options are: the said application will be allowed and the plaint rejected, the said application will be dismissed with the cost, the decision on the application will be postponed to the time of decision of the suit, and option 4, an issue along with other issues arising in the suit will be framed to the effect whether the plaint is liable to be rejected. Here in question number 102, the correct answer is option 1, that is the said application will be allowed and the plaint rejected. Question number 103. Plaintiff files a suit under Order 37 of CPC. The court issues ordinary summons for framing charges issues, and the said summons along with the copy of the plaint are served on the defendant, and the defendant files a written statement on the date for which summons was issued. The plaintiff, realizing the mistake committed by the court, applies for summons under Order 37 CPC to be issued. Here the options are: the written statement having been filed, the suit will be tried as an ordinary suit, and option second, the defendant having along with the summons of framing issues received a copy of the plaint showing it to be under Order 37 of CPC and having within the prescribed time not enter appearance, the suit will be decreed. Option third, the court will correct its mistake by issuing fresh summons under Order 37 of CPC, and option 4, the plaint will be rejected. Here the correct answer for question number 103 is, that is third option, the court will correct its mistake by issuing fresh summons under Order 37 of CPC. Order 37 of CPC provides for the summary procedure. Question number 104. A files a complaint of offence under Section 138 of Negotiable Instrument Act against B, C and D, arriving that B and D had drawn a check on a joint account with C in favour of A, and which check had been returned dishonoured for reasons of insufficiency of fund, and B, C and D, in spite of notice of demand, had not made the payment within the prescribed time. C contends the complaint to be not maintainable against him because though he was a joint account holder with B and D, but as per instructions to bank, checks could be issued with signature of any two of them, and the check in question was not drawn or signed by him. D also contends the complaint to be not maintainable against him because he had served his relationship with B, because he had severed his relationship with B and C, and in pursuance to which the account was opened. Options are: the complaint against C is not maintainable and will be proceed. Options are: the complaint against C is not maintainable and will be proceed against B and D. Option second, contention of both C and D will not be accepted. And option 3, the complaint against D is not maintainable and will proceed against B, C. And option 4, the complaint against all B, C and D is not maintainable. Here the option first is the correct answer. The complaint against C is not maintainable and it will proceed against B and D. Question number 105. A files a suit for ejectment of B from the premises earlier in the tenancy of B under A in Delhi at a rent of rupees 10,000 per month, and after determining the tenancy of B with respect thereto, B defends the suit, pleading that A had orally agreed to sell the premises to B for total sale consideration of rupees 60 lakhs, and of which rupees 5 lakh had been paid in cash, and for a specific performance of which agreement he, though after the institution of suit for ejectment, but before filing the written statement in the suit for ejectment, he had filed a suit which was pending. B contends that since his entitlement as an agreement purchaser is to be decided in the suit filed by him, the suit for ejectment filed by A should be stayed. Options are: the suit will be so stayed, and option second, the application of B for stay of the suit shall be dismissed, and option third, the trial in the suit will proceed, but the execution of the decree, if any, for the ejectment shall await the judgment in the suit for specific performance, and option 4, the suit for ejectment will be summarily dismissed as premature. Here the correct answer is option second, that is the application of B for stay of suit shall be dismissed. Question number 106. A on 7 January 2014 files a suit for recovery of possession of immovable property and mensne profit from B, contending that he had let out the property to B by a registered lease, deed dated 20 January 2012 for a period of 1 year, and after expiry of the said 1 year also B was allowed to continue as a tenant on the same terms and conditions as contained in the registered lease deed, though without executing a fresh lease deed, and that the tenancy of B has been terminated by a notice dated 11th November 2013 under section 106 of Transfer of Property Act 1882, B contends the suit to be not maintainable because the notice of termination of tenancy was of 10 days only instead of 15 days as required by law. The suit remains pending for over 2 years. Options are: the suit will be dismissed because the notice is for 10 days only instead of 15 days as required by law. And option second, institution of suit itself amount to termination of tenancy, and since the suit has remained pending for more than 15 days, the defect in the notice was immaterial. And option third, because of defect in notice, though A will be entitled to decree for possession but not for mensa profit. Option 4, the suit on the avertments made in the plaint and the notice filed as annexure therewith should have been rejected at the outset under Order 7 Rule 11 CPC. Correct answer for question number 106 is option second, that is institution of suit itself amounts to termination of tenancy, and since the suit had remained pending for more than 15 days, the defect of the notice was immaterial. This is the right answer. Question number 107. Suit filed by A for recovery of possession of immovable property is defended by B, contending that though he was in adverse possession of immovable property for a period of 5 years only prior to the institution of the suit, but before the said 5 years, C was in adverse possession of the property to the knowledge of A for a period of 20 years, and thus the suit filed after 25 years of first C and then B being in adverse possession of property was barred by time. Options are: B is not entitled to claim the benefit for the period for which C was in adverse possession and the suit is within time. And option second, B is entitled to the benefit of the period of which C was in adverse possession and the suit is barred by time. In question number 107, the option 1 is the correct option, that is B is not entitled to claim the benefit for a period for which C was in adverse possession and the suit is within time. Question number 108. A obtains from the courts at Bombay a decree against B for recovery of money and has the said decree transferred to Delhi for executing against the properties of B at Delhi. However, B dies though after transfer of decree to Delhi but before service of notice of execution issued on B. Option: the application for substitution of legal heirs of B has to be fulfilled in the courts of Bombay. The application for substitution of legal heirs of B can be filed in the courts at Delhi to which the decree has been transferred. And option third, the application for substitution cannot be filed in either of the courts as the decree because of the death of B has become invalid. And option 4, the application for substitution will have to be filed in the Supreme Court of India. In question number 108, correct option is option second, that is application for substitution of legal heirs of B can be filed in the courts of Delhi to which decree has been transferred. Question number 109. A files a suit under Order 37 of CPC for recovery of money from B, pleading that A given on a loan a sum of rupees 5 lakhs to B via check, which was duly encashed in the account of A, but B had failed to return the said amount received by him by check. Options are: the suit is maintainable under Order 37 of CPC. Option second, the suit is not maintainable under Order 37 of CPC because A has not filed a check which payment was made along with the plaint. Option third, the record of the banks on which the check was issued and in which the check was encashed shall be called if payments is indeed found to be made by check. The suit would entertained under Order 37 of CPC. And option 4, the suit as per the avertment made in plaint is not maintainable under Order 37 of CPC. In question number 109, the correct answer is option 4, that is the suit as per avertment made in the plaint is not maintainable under Order 37 of CPC. Question number 110. A tenant in a premises at Delhi at a rent at excess of rupees 3,500 per month contests the suit by landlord for his ejectment and for mesme profit on the ground that the suit had been prior to the expiry of the terms of the registered lease deed and was premature. The suit entertained and put to trial. During the pendency of the suit, the term of the registered lease deed expired. Options are: at the time of the final decision of the suit will be dismissed as premature having been before the expiry of the term of the registered lease deed. And option second, notwithstanding the suit being premature since the period of lease has expired, suit with decreed or ejectment and for mensa profit for a period after the expiry of the term of the registered lease deed. And option third, the suit will be decreed for ejectment as well as for mensa profit from the date on which the institution of suit. Correct answer is option second, that is notwithstanding the suit being premature since the period of lease has expired, the suit will decreed for ejectment and for mensa profit for the period after the expiry of the term of the registered lease deed. Now let us see the question number 111. One of the conditions laid down in agreement to sell was that sale would subject to the sale being able to settle with its labor and the labor agreeing to the sale. The labor did not agree to the sale. However, certain other terms of the agreement of obtaining the permission under the Urban Land Ceiling and Regulation Act 1976 and of conversion of the property from industrial zone residential use were implemented. The purchaser contended that he waives the term relating consent of labor and therefore the sellers cannot take advantage of the stipulation which the party whose benefit it was made had expressly waived and sues for a specific performance. Options are the purchaser is entitled to a decree for a specific performance, and option second, the purchaser is not entitled to decree for a specific performance. Here, the purchaser will not be entitled to a decree for a specific performance. Question number 112. A plaintiff during the pendency of suit amended the plaint including a prayer for compensation and on which relief additional court fees was required to be paid. However, neither did the plaintiff pay the additional court fees nor did the court give opportunity to the plaintiff to pay the same. This suit, including for the relief claimed by way of amendment, was decreed. In appeal, the defendant appellate contended that the decree insofar as granting the relief claimed by way of amendment and on which no court fees has been paid was bad. Options are the appellate court will set aside the decree granting the relief on which no court fees has been paid only on the ground, and option second, the appellate court will grant an opportunity to the respondent plaintiff to make up deficiency in the court fees as the powers of the appellate court are the same as the power of the trial court. Option second is the correct answer. Question number 113. Plaintiff in a suit claims that the dispute subject matter of the suit had been compromised with the defendant. The defendant disputed the compromise. The court conducted an inquiry and opined that a compromise had been legally entered into between the parties and decreed the suit in terms of the compromise pleaded by the plaintiff. The defendant appealed. Options are the decree being a compromise, consent decree appeal is not maintainable. Option second, since the defendant had contested that any compromise had been arrived at and a trial or inquiry had held favor of plaintiff, the decree could not be said to be consent decree and the appeal is maintainable. Correct option is option second. Now let us see question number 114. A guarantees to B payment of a bill of exchange by C, the acceptor. The bill is dishonored by C. Options are A is liable only for the amount of the bill, not for any interest and charges which may have become due on it. Option second, A is liable not only for the amount of the bill but also for interest and charges which may have become due on it but after B has failed to recover the same from C. And option third, A is liable not only for the amount of the bill but also for any interest and charges which may have become due on it. And option 4, only C is liable for the amount of the bill and for the interest and charges due on it. In 114, option 3 is the correct answer. Question number 116. A files a suit for recovery of money from B before the Court of Civil Judge, Delhi. B files an application under Section 8 of the Arbitration Conciliation Act 1996, pleading that the suit is brought on the matter which is subject matter of arbitration agreement. The said application is allowed and the suit is dismissed. A prefers an appeal to the Court of District Judge. Options are the appeal is liable to be dismissed as not maintainable. This is the right option. And Section 8 of the Arbitration Conciliation Act talks about the power to refer parties to arbitration where there is an arbitration agreement. Now let us see the question number 117. A files a suit in the Court of Civil Judge, Delhi for recovery of possession of immovable property at Delhi let out to B at a rent of Rs 4,000 per month of the expiry of the term of the registered lease, and for recovery of mense profit. B contests the suit and issues including as to the rate of mense profits are framed. The civil judge decrees the suit for recovery of possession as well as for the recovery of mense profits damage for use and occupation at the rate of Rs 6,000 per month from the date of expiry of lease till the date of delivery of possession. B appeals to the district judge contending that the decree for mense profit is bad as the civil judge Order 20 Rule 12 of CPC ought to have ordered an inquiry into the mense profits after pronouncing on the entitlement to the relief therefore. Options are the decree for mense profit is liable to be set aside and the suit remanded for the conducted inquiry. And option second, there is no merit in the contention of B. Here the correct answer is option second, that is there is no merit in the contention of B. Question number 118. A files a suit in the Court of District Judge, Delhi for a specific performance of agreement of sale of immovable property and for the permanent injunction restraining the defendant from prosecuting a suit filed in the High Court at Delhi for ejectment and from mense profits. It is the case A that the defendant had let out the property to A at a rent of Rs 50,000 per month via unregistered lease deed. That subsequently the defendant had orally agreed to sell the property to A but had turned dishonest and instead executing the sale deed in favor of A, had terminated the lease and sued for ejectment of A as a tenant. A also seeks interim relief restraining the defendant from prosecuting the High Court suit. Correct answer is option third, that is plaintiff insofar as for the relief of permanent injunction will be rejected. Question number 119. A files a suit for the recovery of Rs 2 lakh in the Court of District Judge, Delhi when the court of the lowest grade competent to try it within the meaning of the Section 15 of CPC, the Court of Civil Judge, Delhi. However, no objection is taken neither by the court nor by the defendant. In this regard, the suit is decreed. Option A, the decree is a nullity and cannot be executed. Option second, the decree is a nullity but only if appeal is filed against and without the filing the appeal, the defendant in execution of cannot object on the ground of it being nullity. And option third, the defendant having not taken any objection, the decree is valid. This is the right answer, that is option 3. Question number 120. B owes to C a debt guaranteed by A. The debt becomes payable. C does not sue B for a year after the debt has become payable. Correct answer is option second, that is A is not discharged from his sureties. Question number 121. A and B stand surety for payment of amounts due by C to D. D releases A from his suretyship. Options are B automatically stands discharged. Option second, B does not stand discharged merely from D releasing A from his suretyship. And option 3, though B does not stand discharged but can separately seek relief against A as a co-surety. Here the correct answer is option third, that is though B does not stand discharged but can separately seek relief against A as co-surety. Question number 122. A claiming title to an immovable property on the basis of registered agreement to sell, power of attorney and will from the registered title holder in his favor is forcibly dispossessed from the property by B, also claiming title on the basis of registered agreement to sell, power of attorney and will etc. from the original title holder. A files a suit for declaration that the agreement to sell, power of attorney and will in his favor being prior in the point of time to the agreement to sell, power and attorney and will in favor of B. A has a better title to the property than B. B contends that suit is not maintainable since he is in possession of the property and A has not claimed the relief of possession. A states that his right to recover possession will arise only after declaration sought by him is granted. Here options are the suit is maintainable and option second, the suit is not maintainable. Correct answer is the suit is not maintainable. Question number 123. Against an order of dismissal of suit consequent to rejection of plaint, options are revision petition under section 115 of CPC lies, a petition under article 227 of the Constitution India lies, and option 3 an appeal under article 96 of CPC lies, and option 4 an appeal under order 43 of CPC lies. Correct answer is option 3, that is an appeal under section 96 of CPC lies. Section 96 talks about the appeal from original decree. Question number 124. In an appeal against a decree from recovery of possession of immovable property and for mentioning profits, pendent, light and future, court fees as to the plaint is payable. Court fees besides on the plaint also on the mentioned profit decreed is payable. Option 3, no court fees is payable, and option 4, fixed court fees is payable. Here the correct answer is option second, that is court fees beside as on the plaint also on the mentioned profit decreed is payable. Question number 125. A child born of a marriage which has been declared null and void under section 11 of the Hindu Marriage Act 1955 is a legitimate child and has a share in the property of his father, is an illegitimate child and has no share in the property of the father. Option 3 would have been legitimate and had a share in the property if the marriage had not been declared null and void, but since in the case the marriage has been declared to be null and void and has no share. Correct answer is option first, that is a legitimate child and has a share in the property of father. So that's all. This video we have completed the DGS HGS paper of 2015. It is a humble request, please like, share and subscribe our channel, and also please join our Telegram group, the link of which is given into the description section. Thank you so much. Thank you for watching.